So thank you, folks. Thank you for being patient as we get this third session underway. It's actually been an incredible day so far. We started the day with two individuals who have served as a source of inspiration to many of us in India for being pioneers and brave hearts who, in the face of adversity, have had the courage to stand up to injustice and seek changes in the way the legal system operates. Mavri Devi and Kavita Srivastav, both of whom provided us all with much inspiration on how to prevail against all odds. So that was our first session in the morning. Thereafter, we had a very enlightening session with two experienced HR professionals who shared their experiences on the PoSH law, as well as in creating a culture of respect and a culture of compliance, both of which are very close to us at Rainmaker. Delna Elavia, head of HR at ST Lauder, and Kashmira Prabhu of Nosal Limited. Both of whom took time out to explain the nuances and their respective experiences. So that was a wonderful session. And now for our third and final webinar, commemorating the 10th anniversary of the PoSH law, we're looking a little bit into the future. Our next session is Future Outlook, Advancing Workplace Inclusion. And we have a panelist who needs absolutely no introduction. I'm really delighted to welcome Karuna Nundy, advocate, Supreme Court of India, and international lawyer. So a little bit about Karuna. Karuna is a distinguished legal professional specializing in civil, commercial, and constitutional litigation, primarily practicing in the Supreme Court of India, high courts, and tribunals. She has a dual qualification to practice in India and the state of New York, and her legal expertise extends to advising governments and consulting on international law with global organizations such as UNICEF, UNDP, and the IPU across various countries, including Bhutan, Bangladesh, India, Pakistan, the Maldives, and Nepal. As a member of the Global High Level Panel on Media Freedom, led by former Chief Justice of England, Lord Neuberger and Amal Clooney, and a participant in the Columbia Global Experts Panel on Freedom of Expression, Karuna contributes significantly to shaping legal policy and advancing constitutional and media laws. Her recognition in Time magazine's list of 100 most influential people globally in 2022 reflects her profound impact in the legal sphere. Karuna's educational journey includes a BA and MA law from the University of Cambridge. She also pursued an LLM from Columbia Law School, where she actively engaged as a human rights fellow. Her commitment to advancing justice, constitutional freedoms, and human rights has established her as a key figure in the legal landscape, both in India and globally. Karuna, once again, welcome to our session, and we are all absolutely delighted to have you join us and share your experiences with us and the group. Karuna, we've actually had a very busy day in terms of really looking back on, the Vishaka judgment, changes that happened, Bhavri Devi's journey, which no matter how many times you hear, it still feels like it's the kind of trauma that no individual should have to go through. Yet to pick yourself up and then advance the cause of justice for uh, the marginalized women, children, and so on and so forth still takes a lot. And it's been a really overwhelming day for many of us who've sort of been participating from the morning. You yourself have been at the forefront of many of these cases, arguing, putting forth your arguments in case and advocacy in terms of it's really a very good reflection of how civil society can come together with lawyers, activists, and the judiciary to make a big difference, a tangible difference to the law, to the legal system, to the way we operate, and a real difference to people's lives. Um, with respect to the PoSH law, and it's now 10 years of the law. What next? I mean, looking to the future, what are the things that we as uh, we as the people of India, we as the right-thinking Indians, we as people who want to make a tangible difference to the way workplaces are. Uh, Very quickly, what do you see as things that we need to be focused on in order to make a difference, make a change, and also keep improving, right? Because nothing is perfect. There's always room for us to make a difference, make a change, and do something even more than where we are today. So keep moving forward in a sense. Your thoughts?
Um, the Prevention of Sexual Harassment Act is extremely important legislation. And the reason it's very important is that there it provides a structure that, if used right, can really kind of hack down the patriarchy down to a level that allows women and, in fact, queer people, and I'll come to that, to flourish within an organization. Now, why do I use the word organization and not merely company? Because it's any workplace at all. So what we have been doing, and sometimes people are surprised to see me and they say that, oh God, like you have all these cases in court, why are you here, right? But I think for me, the fact that we see those shining eyes, the fact that we see that transformation happening, and we see a lot of crimes being prevented, so for me it's a opportunity to be a part of that and to help be a catalyst in that and to participate in that. So if we can go straight into our PowerPoint, and I promise that it's not very text heavy, it's mostly pretty pictures for you to look at while we discuss important things. Rishika, will you right. So Rishika is going to share her screen in a minute. Now, I've been working at this for about 20 years. And when the Vishakha guidelines came in 1997, I sort of saw them and felt that, I mean, it's a very important thing, right? I then worked for Meenakshi Arora for a couple of years, who was the lawyer on Vishakha.
Yes, yes.
And I mean, that was very interesting because, of course, Vishakha is in itself, for the lawyers out there, judgment that really takes international law forward and international rights law forward by bringing it home and to our jurisdiction, but then really bringing it home into people's lives, right?
Right.
Because before Vishakha, there was no anti-sexual harassment civil regime. So there was only a criminal remedy. And that criminal remedy was a bit odd. It was only Section 509. It's still odd. And after our efforts and Kavita Srivastava was actually a part of that effort, to change the law in 2013, it's clear to me why it's odd, and I'll come to that. It speaks of words and gestures that outrage the modesty of a woman, right? Now, what is that modesty? Do you need to have modesty before it is outraged, before you can say that you were sexually harassed? The word eve-teasing that was thrown around in a completely ridiculous manner for the longest time, rather than sexual assault or sexual harassment, and minimizing, as is typical, the crimes against women, mean that Section 509 had its own issues. However, it was still a blunderbuss where a scalpel was required, because in many situations, you can have at the lowest level an apology, like say somebody comes and says, oh, you look so hot at work and it's not okay, and you don't want to, and you've had enough and you don't want to put up with it, right? Or it can be a mediation if it's something that the woman wants, or it can be docked pay and a formal apology, or it can be ramped up to a suspension, or it can be a firing.
Termination, yeah.
Somebody being fired. So in these sorts of situations, then, I think Vishakha was not only important, the fact that the act then came in 13 years later and without any discussion on the floor of parliament. No, sorry, 16 years later.
16 years later.
And I was watching it very closely, and there was no discussion on the floor of parliament, and it just went through. It's a sign, on the one hand, that our society doesn't take it very seriously, but on the other hand, that our society desperately needs this law.
Yes.
right? So now coming to the law, as we all know, especially those of you who have attended earlier parts of the day, that it provides a structure. Number one, under Section 19, you must have workshops. Now, the reason that I myself conduct those workshops and I involve my team in them is that there's a lot of confusion today around what it means to sexually harass someone. And sometimes that leads to discrimination. And at the moment, we don't have an anti-discrimination law. This is a huge lacuna in that law. And people can't go in our law, and people can't go to high courts or bring suits that take 20 years for every offense that happens, right? So therefore, to really to sort of, I also think it's good practice to support people to be their best selves. So what we do then is that we divide people into groups of men, women, and other, right? And queer folk. And there, people discuss amongst themselves what it's been like to be a woman or a man or a queer person, right? In the world as well as in the work at work. And there's Chatham's rule, which is that nobody's allowed to speak of the experiences that are shared outside the room, or even, and that's double confidentiality, they're not even allowed to refer to it, right? So now, in such cases, what we find is fascinating, because it means that, for instance, that men share that they were forced to be bankers when they wanted to be designers, and the experience of having their mother ask for money for a handbag and how they felt humiliated. And also, in the beginning, we also hear a lot of guilt. Say that, oh, but I have it fine. I suppose it's the kinds of workplaces that I've brought into. But there's a lot of guilt, because they say, well, I have it okay, and I just want to hear how to support women. But then we don't look at the benefits of this progressive legislation and the benefits of cutting down the patriarchy that limits them as well, for them. It also means that then everyone is much more open to listening to each other once the floor is opened up. We started having queer groups more recently, and it's been a revelation. And every workplace that we worked in has welcomed the move and has also then subsequently, some of them, not all, taken action to support queer people, right? Now, and then, of course, we go to the law and how the law works, but also the criminal law. What is a cognizable offense? What is a non-bailable offense? In addition to the various options that are available. Now, the second thing is, I see that our PowerPoint's ready. Rishika, can you start sharing? Now, the thing is and so in the beginning, what we've done is that when it's been a set of workshops that we're going to be having with the company, right? What we have done is that we have workshopped a draft policy that's already there, or a draft policy that we have brought, right? To see what works, what doesn't work, what is it that how appropriate is it for the particular workplace? Because typically when companies want to save money, what they'll do is that they'll give a cut-paste job to an HR professional, and then they'll have a policy and they'll tick the boxes, and they'll be able to tell their, they'll be able to kind of just put it in the audit report, right? We only honestly get called in when people are serious about this, when people want to deal with gender at the workplace.
Yeah, if it's a check the box exercise, there is no need to sort of get experts in, clearly.
Yeah, exactly. So in such a situation, then we have had a variety of responses, right? So I use the example of Penguin Random House, because Penguin Random House has been one of the leaders in this regard. Now, when we had our initial discussions in the workshops, a couple of interesting things emerged. One thing emerged is that everyone, the women and the men, agreed that they didn't want the victim to be only defined as a woman. They wanted the victim to be gender neutral, and they also wanted the perpetrator to be gender neutral.
Sure.
Now, PRH is a very specific kind of place. It's a place where there are a lot of women in senior management. It's a place that is majority women, but I think the first thing is more important, that there are a lot of women in senior management, and women across the board said this. And it's distinct from the criminal law as it stands now, imperfect though it is, which looks at the victim as being gender specific and only women.
Only women, correct.
Right? Now, the reason for this, it's not entirely, there are good reasons for this. As I said, it's not perfect, but there are good reasons for this. And the reason for having the victim be only a woman is that you take a situation in Eastern UP where the act is the same act, right? A woman and a man having sexual intercourse. And then it's only about consent. So if I was the lawyer of the Rajput man, say, who raped the Dalit woman, I would say, go and file a rape case now against her. Because then hers looks like a backlash. Now, to us today, this may seem completely incredible and something that nobody would believe, but don't underestimate how power structures work, right? And so therefore, it was very interesting to me and very eye-opening to see that in PRH, this was the approach, which we, of course, implemented. Slide, please, Rishika. Slide. No, so stop. Yeah, just right here, please. Now, so then what happened is that there were other things that emerged from the discussion, because of course the discussion was focused around gender, and the discussion was focused around not just discrimination that was sexual, but also other kinds of gender discrimination. So what do I mean by that? If somebody touches me on the shoulder and says, "Hey, you're so hot," right? That can result in a jail term. In fact, a compulsory jail term under Section 509.
Right.
Somebody shouts at me and says that you're so stupid because you're a woman, then that is something that doesn't result in any penalty at all, except for a suit that it's not the right tool for it at all. And we don't have...
Or action in accordance with the company policy or whatever. Outside of the legal system, that's...
So the equality policy then that we brought in, so there is a draft equality law that was proposed by Shashi Tharoor, but more importantly, it was drafted by Tarun Khaitan, who's an academic now at the LSE and a friend. Now, that law has a lot that is useful, and what we did with the PRH equality policy is that we brought sort of those components, but also looked at what equality meant within the organization, and brought that into an equality and non-discrimination policy, which meant that instances like the one that I just spoke of were addressed. Why is this fundamentally important? And I'll come to that, and I'll come to a bit of detail in the equality policy. Now, in terms of course, when we just look at prevention of sexual harassment policy, there are a number of things we have to do. For instance, we need to look at what the parent company law looks like, because not only do parent companies, where there is a parent company, of course, because let's remember that this law applies to workplaces that are of only 10 people strong, So it actually applies to the large kirane ki dukaan, right? The fact that we don't have most of women employees, and indeed employees in general, in the formal sector. In fact, over 90% of employees are in the informal sector, and we'll come to that. means that these structures are important in all our minds, in all our lives, in fact, because we all work in the formal sector. But unless unless there are some of you who are freelancing, but actually even you will be covered with most of the organizations that you work with. But it means that a large part of our populace isn't covered, and that's a problem. The law does address that, so we'll come to that. So for companies like Bertelsmann, we just look at sexual harassment specifically, and then there are companies like PRH where we look much more widely on equality in the workplace. Slide, please. So if we look at the equality in workplace behavior policy, that it includes compliance with the law, yes, but that's only the bottom floor. It includes addressing patriarchies and other discriminations in the workplace. So if you are a Dalit woman, you don't have to leave the fact that you are Dalit at the door and pretend that it doesn't exist. Redressing complaints in a just manner and exemplifying a progressive work environment. So it has the sweet acronym CARE, which is about nurturing our employees, and kind of making sure that people are not having to worry about this, that, and the other, and can bring their best game to work. That's why they're there. And they can then therefore serve a double bottom line, if not a triple bottom, right? One that has an interest in making lots of money or making great books, but also in employees flourishing for their own sake, right? It includes, just like the law says that any policy must, temporary part-time contractual employees and consultants engaged on a project basis. Next slide, please. So I was speaking about the victim being gender neutral and being male or female. And in fact, as an aside, it's important to mention that when we were working on the 2013 criminal amendment law, the anti-rape laws, then we were very clear, and in fact, it was communicated to the government that the victim should be gender neutral and the perpetrator should be gender specific, because almost every crime of sexual assault is committed by a man. Victims are queer people, trans people, people across the board, men, However, there was some confusion in communication with the cabinet, and it just became female. And of course, amendments subsequently have been extremely difficult. Slide. These are the different kinds of harassment that sexual harassment as defined, and it could be quid pro quo. So X harasses Y and says, I'm going to give you a job, or come out to dinner and I'll give you the project. It could be implied, come out to dinner with me at night and I'll discuss the project. She says, I'm not available for dinner. Can we discuss the project later? And he says, no, I can only do it at dinner. That is quid pro quo harassment. Hostile work environment is that Amit shows Shalini porn, or Amit shows Rajesh porn, and that's a hostile work environment for me. Physical harassment, I think it could also be a hostile work environment. It doesn't rise to the same level, but if Amit and Rajesh keep talking about how hot so-and-so is or how ugly so-and-so is, and it bothers me, right? Because then what happens is that the culture in the workplace becomes something, obviously not one comment, but maybe a number of comments, because it makes a woman's or a queer person's, or in fact, in this case, a man's worth at work linked to how attractive they are versus how good they are at their work. There are lots of examples of this. I'm happy to go into it. President Obama at the time had called Kamala Harris, who was Attorney General of California. He said not only is she the most brilliant Attorney General, she is also the most attractive. And there was a huge debate on the internet with regard to this, because some people said that, like, he's a good friend, and he also said she's the most brilliant, right? So why is it not okay to say this? And I was interested, and I kind of looked at a bunch of studies, and to comment on a woman's looks, whether it's in the political sphere or whether it's at work, means that she is less likely to be promoted, she is less likely to be elected, she is less likely to have a pay raise. And the interesting thing is that if you comment on her looks either way, if you say she's ugly or if you say she's beautiful. There's, of course, physical harassment, verbal, written or graphic, non-verbal, and any other unwelcome sexually determined behavior. Slide. Slide, please. Another one. Backlash discrimination is very important. The reason that we have backlash discrimination in the policy is because when after a complaint of sexual harassment, there can be a lot of subtle marginalizing of the person by others, because sometimes they feel that it's something, the old boys network would sometimes close in, right? And because we don't have a non-discrimination law, this becomes really fundamental. So marginalizing an aggrieved employee in the workplace with regard to their role or responsibilities, this is going to change. It's not going to be her or his anymore. This was made about 8 years ago. Not including a specific qualified and willing aggrieved person with a protected characteristic, and that is described as gender, ability, as in whether you're disabled or not, sexuality, caste, etc., or promoting qualified and willing employees of groups other than protected groups in teams. And the qualified bit is very important. Socially ostracizing, and this is something I think that both women and Dalit people and queer people, anyone from a protected characteristic group will understand very clearly. Intimidating someone, spreading false rumors, or any other behavior that may commonly be construed as retaliatory. Slide. How to be surer of what sexual harassment is. Now, believe it or not, the acronym just came up organically. We were just kind of workshopping it, and I was, writing it down on the board, of sort of bringing ideas and, either eliciting ideas, but also just having brilliant ideas come on their own from the groups, right? Is it a sexual behavior? Is it unwelcome? Now, this is important. If she's okay with it, then it's fine. It could create a hostile work environment for a third person, but if she's okay with it, that instance is fine. Does the comment or behavior make me uncomfortable? Do I consent to it? I mean, there are so many times that things happen and we're not sure whether it's against a policy or whether it's okay or not. Is it repeated? So somebody comes and says, nice shoes. Now, that's fine, right? But if somebody comes every day and says, nice shoes, that's going to be a problem. I think the third time, you're going to be annoyed by it. Is an escalation required? Because we also do role plays where we say that, look, let's practice saying no. Because the reason that this policy is here, the reason the workshop's happening, is because the organization is backing you. You know why the organization is backing you? Not only because it's the right thing to do, but in addition, because if an organization not only has these workshops, but actually deals with the problem rather than the bad old days, or even now, actually, in some cases, where things are swept under the carpet, the organization saves themselves from liability, from criminal and civil liability. Sometimes from the long arm jurisdiction from another country where the parent is, right? So therefore, the more senior the employee, the more senior, if you're in a supervisory role, it's even more your responsibility to actually deal with it. However, once you know the organizations behind you, take the opportunity to say, that's not okay with me. Could you not do that? Right? And then we practice that because I think women are, in particular, are trained to manage things and do all this the balancing of 100 things that we are required to do when we're at work, rather than say, this is my space and let's just deal with it in a way that we're supposed to. Now, with regard to whether it's harassment or not, would a reasonable person consider the behavior harassment, right? This is important because there's an objective standard, and this is feminism requires that there be a subjective standard. So therefore, how you or I experience the harassment is very important. But also it can't be that somebody comes and says, oh, what a beautiful day it is outside, and you say that I am feeling harassed, right? So there's got to be an objective standard as well. So would a reasonable person consider the behavior harassment? Now, this next bit is very important. Would a reasonable woman consider it? If you are different from the hypothetical reasonable woman or man, communicate this to your colleagues or to any person harassing you, right? Like if you are a little more conservative, like say you are somebody who is a hijabi and feels that she doesn't want to go to dinner because she's not comfortable with being in places where there is alcohol around, but she's very comfortable, for example, having the discussion elsewhere, and that's a reasonable accommodation that can be made. That if she doesn't want to go to the dinner, if she does want to do it elsewhere, have a conversation elsewhere. This is very important. Don't blame yourself. Don't ignore sexual harassment in the hope that it'll go away, because somewhere it'll eat you inside. It'll eat at you inside yourself, and it'll affect your performance at work. So the workplace has an interest in dealing with it. Slide. There is some, having done this for, as I said, about 20 years, we see a pro-workplace bias somewhere in many places, and to some extent, it's the nature of the beast because it's a structure that's within the workplace. At the same time, I think there are two things that can help. Local committees are defined as Section 2 of the Act as local complaints committees, which are government bodies that anybody can go to. Now, these are fundamentally important because, slide please. Slide. The unorganized sector in this country is really massive. A sector with no written job contracts, where people work for 1 year or less, where there is no regulatory or supervisory body to look at this. So therefore, to have a government body is fundamental. But in addition, there's another important role that these local complaints committees do. What they do is that they keep our committees honest, right? So if there is an option to go to an outside committee, then it means that you just have to perform better. Otherwise, she has a choice. Slide. Again, 93% of informal workers in the total participating workforce. And I think that one thing that also another interesting figure, female informal employment was 82% compared to 78% among urban male workers. Slide. So essentially, I think that there are a number of takeaways. One, prevent rather than come in after the fact. Two, make sure you address the problem, because today women are empowered in all manner of ways. Not only could your CEO get cancelled, not only could this be a huge problem for your brand, but more significantly almost, it could be the more senior employees as well as the company itself could be civil or criminally liable if you don't address the problem. Number three, addressing other kinds of vulnerabilities is important because people are not just one thing. People aren't just women, you know. People are usually women and something and a number of other things. And see if yours is the kind of organization that men can be protected. There aren't a lot of these, but there are a very few. Or not can be protected, but need to be protected in the same way. Yeah, and shall we open it up to questions? I would love to hear from everyone and their own experiences.
Thank you so much, Karuna. Very, very enlightening, actually. And I had a lot of ideas, thoughts, comments popping into my own head as you were speaking. But as you rightly said, let's wait till the end. So I have a couple. I'll kick them off, and then of course, everybody who's on the webinar is welcome to sort of pose their questions as well. So first things first, and I'm not sure if I missed this, but the equality policy for PRH that you showcased, that is also their PoSH policy, meaning it's all bundled, is it? Is that what they were trying to do?
No, so what we did there is that we created an equality policy that included sexual harassment as well as other kinds of discrimination. You know,
Right. Okay, because the understanding of the law is that if you have a complaint of sexual harassment, if a woman is filing a complaint of sexual harassment, then she naturally goes to the internal committee. But if it's any other gender, then you'll have to go to a different committee because the law empowers the IC with the powers of a civil court only when the complainant is a woman. So,
correct. That's a
right?
very
So,
good question. So I'm glad to be having this conversation with a lawyer. Excellent question. Now, what the law provides is a flaw, right? And what the provides, as you quite rightly said, specific powers with regard to is when a woman is complaining. But there is a variety of things that a company can do that is not, that is above that flaw.
sure.
So therefore, you're right that the committee qua a male victim, right, would not then have the power of a civil court in that same manner when they're seeking evidence or they're asking for.
Sure, sure.
But primarily, the power that these committees have is not derived from that. Primarily, the power that these committees have is derived from the fact that they are constituted by the organization. And the organization is then recommended and has the power then to do various things under their own employment policy, right?
Understood. But the organization is also deriving its power from the statute and specifically Section 4 of the statute that allows them to you pass a Section 4 order constituting the internal committee. So there are very specific sort of guidelines that stipulate how you can actually set up a committee, and it's all flowing directly out of the statute. But I hear you, and I think
No, I just want to be clear on this. I just want
yeah,
to be clear on this so that there's no doubt, right?
yeah.
Let's look at Section 4. And also then let's, in addition, let's ask others what questions. Constitution of an internal complaints committee, right? Every employer of a workplace shall, by an order in writing, constitute a committee to be known as the internal complaints committee, provided that where the offices or administrative units are located at different places, the ICC shall be constituted at all administrative units or offices. 2,
That's right.
the internal committee shall consist of the following members to be nominated by the employer, namely a presiding officer, 2 members from the employees, 1 member from the NGO. Presiding officer and every member shall hold office for such period not exceeding 3 years. 4, the member appointed from amongst the NGOs and associations shall be paid such fees, etc. 5, where the presiding officer or any member of the internal committee contravenes the provisions of Section 15 or has been convicted for an offense or inquiry into an offense, has been found guilty in any disciplinary proceedings or has abused their position, then they shall be removed.
That's right.
So what that does is that it tells you what the conditions are for an internal complaints committee when the victim is female. It does not prevent you at all. There is nothing there that prevents you from having the same committee address the sexual harassment of others, non-women,
Sure.
people who are queer, people who are men. And as I said, that I think that in very limited situations will sexual harassment against, for the victim to be gender neutral, be advisable. But there are, and PRH is a example of that. But there is nothing in the law that prevents you from constituting a committee that addresses all genders, because the law is an enabling law. It is not a prohibitive law. Now, these are two very different things.
Of course, of course. Fair enough. You and I will probably agree to disagree on this because my view is that the law statute is specifically for protection of women at the workplace from sexual harassment, and therefore
Honestly,
the second the more of a comment slash question really is the role of the LC, and you made some very really valid points in terms of the fact that uh, many times what we tend to sort of we don't really overlook it, but a lot more attention is paid to the role of the IC, right? Because corporates have to constitute the IC and all of that. And very often we fail to realize that a large part of our workforce, the women folks, are in the unorganized sector. They are the ones who, sort of many of them who don't have anywhere else to go other than either a local committee or then otherwise you have to just go to a thana or a police station to sort of get relief under criminal law. But if you had to go anywhere for civil relief, then the local committee is really the place to be. In your experience, have you seen a lot of sort of, is that the local committee channel or that recourse to justice through the local committee, is that being used? Are women really sort of from the unorganized sector really stepping up and saying, I'm going to get my rights, I'm going to get justice, and I'm going to approach the local committee to get me justice? Are you seeing a lot of that?
most of these local committees aren't set up, Antony. So that's
Hmm.
a big part of the problem, right? So they don't exist. Secondly, even if they do exist, nobody knows where they are. So I haven't personally heard of a single instance where a person has gone to a local committee, right? Shall we just quickly, I'm keenly aware of the time. Shall we quickly
Yes.
just go through these 6 questions?
Sure.
You want to read them out?
Yeah, I'll just quickly
Sure.
so the first one is, how do you deal with the defense? I did it by mistake. It was not my intention to make her uncomfortable, and it could have actually been a genuine mistake. How does the IC ensure justice in this case?
This is a very interesting question. Essential anonymous attendee, um, and that is your prerogative. Look, if somebody, like, if you go and kind of caress somebody and say, such beautiful material, right? That is something that, or let's use something that's kind of more egregious. Say you sort of touch a private part of some kind, a breast, for example, and say, such beautiful material, right? And you say, I did it by mistake. Now, even in the criminal law, right? And this is the only place intention is really centrally relevant, because you have mens rea, which is the criminal intent, and the actus reus, which is the action, the impugned act, right? Even there, like, it would be 9 times out of 10, you would be convicted, right? Under Section 509. Now, in a civil situation, the standard is the balance of probability.
Probabilities.
But even if you didn't intend to do it, right? The fact that you cannot per se, that you cannot in any event touch a woman's breast, that is never okay, whether you were intending it or not or what, right? Means that there is a objective standard working always with a subjective standard, you know? And the committee, therefore, which is why also it's very important, since committees are doling out justice, right?
Yes.
It's very important, I think, for committees to have an understanding of how all of this works, what natural justice means in effect, in the nitty gritty, you know? So while the law requires that, I mean, I think it's very important to focus not just on workshops for the larger team, but is also to very much focus specifically on the complaints committee, because this is, you could be telling someone that you have committed this act or not, that you are a sexual harasser or not.
Correct.
No, it's a big thing.
Perfect. We have a question from Shama. Can you distinguish between being excluded and feeling harassed? Let not be sexually. I'm not quite
Yeah,
sure. Yeah.
I get what she's saying. Oh, actually, I kind of get what, I half get what you're
Yeah.
saying.
There's some. Yeah.
Want to type in some more and clarify? I think that being excluded could just be being socially excluded, where a bunch of people are, not talking to you because they don't like you, right? Now, this is not good at the best of times, but
Right.
it could be that they are saying, "Nahi, khane pe to unke saath nahi baithna, wo dalit hai," right? Which is, you are being excluded because of a protected characteristic. Or it could be because the boys are all sitting together and making, old boys jokes, right? Which are sexual, and you are not, you're having lunch by yourself somewhere at a different table because you're part of the engineering team, or you're part of um, a typical board, which requires one moment, right? Um, so, and feeling, so the last part it is a bit unclear. Now, going on to the next one.
Yeah, Rivia is asking if an IC of an organization looks at the complaint of a man, given the policy gender neutral or gender inclusive, where would the appeal lie? I guess appeal from the IC, I suppose, is where is the question.
There could be, it wouldn't be a formal appeal in the same way, but there
Hmm.
could be a suit, there could be, uh, in some cases, a writ petition. There are
Sure.
various legal remedies that could happen. Some
Sirisha is asking.
organizations, sorry, Rivya, some organizations where there is a structure, like even within the country, whether it's a subsidiary and there's a parent, or and then there's a kind of super parent elsewhere, right? There are sometimes appeals processes that can be built in this way.
Into the company's system itself,
Own
is it?
structure. Yeah.
Yeah. So if it's from a man, I guess that would be possible.
Yeah.
Sirisha is asking, with the rise of work from home lifestyle, how do you see PoSH regulations law adapting to new workplace environment, and what are the challenges in investigating virtual or online instances of harassment in your
Some
experience?
places, well, in some cases, it's actually been easier because in some cases you have
Evidence.
evidence.
There's a digital trail.
We have I recently found myself defending the first man accused of sexual harassment that I have ever done, as I said, in 20 years. And this happened because I was defending him. I was arguing as counsel his matter in a different, with regard to a different issue. And then suddenly this came up. Now, I looked
You
at
had
it.
to defend him.
Absolutely not. I don't have to defend him. The Advocates Act does not require me to do that.
Sure.
But I looked at it, and I looked at whether I had to feel within myself, like I had to really feel in my gut that he was innocent. Otherwise, I was going to step away
You would, yeah.
in a manner that did not prejudice his case. Let me be clear, that would be very important. And this woman said that she'd been sexually harassed, and in a WhatsApp chat. Now, we sent that WhatsApp chat to Truth Labs, right? To a forensic lab run by former CBI, because the case that I was defending him in was a criminal case in any case, run by former CBI forensic people. And we got what was actually the verified chat before us, right?
The actual full chat with the flow and everything. Okay.
And it became clear that she's saying it was literally like you cannot, and the argument, and literally I said this in court and we got a stay order, that you cannot say something like, and I'm not going to go into the specifics of this case,
Sure.
that that's a nice tree, and she says I'm feeling sexually harassed. That's not a thing. you know. Number two, there was also videos of, because a lot of this happened, the allegations were located in a fact pattern during COVID, and then during COVID, the meetings were on Zoom or Gmeet or whatever, right? They were all online,
Right.
and so some of those had been recorded, which was incredibly helpful. Because I think the thing is that when you are blatantly lying about one verifiable thing, the likelihood that you're lying about other things is also so yeah.
Definitely casts a cloud on your credibility as as somebody who's testifying as to an event having happened. Definitely. So
I think it
especially
goes
if
to the
it's
heart of the credibility. Like if there's the one verifiable fact that you have put out
yeah,
is a lie, is
yeah.
not just on the subject to interpretation, which a lot of things are in life, but is a lie, you know.
And on balance of probabilities, then in any event that is sufficient for you to rule in favor of the other person in that sense.
Yeah,
It
but we
adds
have
up,
a
right?
criminal case. We have a
Yeah.
criminal case, and
This
we're
was a criminal.
caution.
Great. The final question, Karuna, if IC and its constitution is filled with so much legality and technical understanding, how fair is it that HR or management is responsible to fairly implement this within the organization with no legal knowledge? This comes to also the point about whether the external member should be an NGO person without any legal knowledge, because it seems increasingly that the job of an IC, a quasi-judicial function, really
Yeah.
requires a good understanding of how a civil court would work, should function, right?
So I tell you something. A lot of the stuff that I'm speaking of is actually natural justice.
Of course.
Okay. And natural justice means what is fair, what is
Yeah,
fairness. So the reason, I mean, I feel that we have to be very careful about this stuff, because not only if it's true, should it hold up in a court of law, should it be challenged, right? But if it's untrue, then you can't penalize or label somebody who hasn't done it. So
correct.
therefore, but what is natural justice? Natural justice is a lawyer's two words for fairness. You
That is
know,
true. That's how the Supreme Court has also defined it, right? Fairness.
the Supreme Court defined it in a variety of ways, in a variety of judgments. Um, yeah, you're right. I mean, in one judgment, they have defined it as fairness, and it is basically fairness, right?
It is. It is.
So, but of course, because we're lawyers, Antony and I, and because we deal with such things on a regular basis, right? Fairness becomes something that we think very hard about.
We do.
And then, right.
Our last question so far is regarding the discourse of making the PoSH law inclusive for all genders and those of the LGBTQ community. Would that take away from what the law intends to achieve? Is the country ready for that change? I think this question is being addressed to the absolutely right person uh, to be able to give a response on this. Karuna, what do you think?
Let me, Nancy, let me put your question in a slightly different way, right? The same question that you're asking. Is the country ready for queer people not to be sexually harassed?
Hmm.
Maybe, maybe not. My question to you is, does it matter whether the country is ready? My question to you is that is a country not its constitution? And when the Supreme Court, even while saying that queer people should not be married, right, recognizes multiple layers of discrimination and ways to address them, um, let us be quite clear about what our country also is. It's a great country.
Also, I mean, I think that is the difference between being a constitutional democracy and being a country that's run by the majority, right? India has the Republic of India is has deliberately been crafted as a country that is a constitutional democracy, run by constitutional values. Therefore, whether or not a large part of the country thinks in a particular fashion, ultimately we look to the constitution and the judiciary that interprets the constitution to say uh, what are your rights and what are you entitled to, and so on and so forth. So while right now we do not have the marriage equality judgment didn't quite go the way many of us would have. You're right, Karuna, in terms of responding to Nancy's question. I think that's really the way I would look at it as well. We Yeah, I think those are all the questions that we have. uh yeah, anybody else, last call, because before um Karuna sort of winds up the session. If there are any other questions we can ask, otherwise we will have to close the session. We're already a little above schedule. But I'm going to say that it's these 9 minutes we are taking from you, Karuna, because of the time that
Not
we
at all.
lost when you didn't join. So I'm not feeling guilty about taking the extra
No.
10 minutes from you. But no, I think this has been a wonderful conversation. We've learned a lot, from somebody who's really spent a large part of their professional life sort of in advocacy for causes such as these. So there's definitely a lot we take away, and we'll we'll definitely come back to you if we have any sort of sort of frameworks to create, or clearly you're the right person to sort of advise on these kind of frameworks and policies, etc. So we'll definitely come back to you should something like that arise. And any last thoughts you want to leave with the audience and the folks who will see this video post? We're going to post this on our YouTube channel as well. So is there anything that you'd like to leave with them before we end this call?
Um, there's lots of things that we do in our work that are just everyday, regular things. The work that we do in this regard, that is required by law, of course, prevents a real opportunity. And it prevents the opportunity of bringing our colleagues onto the same page, releasing them from anxieties, fears, um, feelings of insult, of voice being suppressed, and allowing them to bring their best selves to the table. So this work is actually important work. This work is work that serves the Constitution. It's work that serves the country. And most importantly, it serves your organization and it serves your colleagues to flourish in a way that may not have been possible before. So good luck.
And it also helps, the bottom line and the top line of the company, right? Happy employees, diverse workforce, inclusive workforce. Everybody is happy and everybody makes more money, and I think it's a win-win situation, really. So it's something
Okay,
that wonderful. Thank you so much, Karuna.
that's a
It's
pleasure. Thank you
really
so
been
much for
wonderful.
having me.
Thank you.